The backstory of how the Vale of Glamorgan Council, accompanied by their vet, Mark Evans, of Valley Vets Cardiff, raided my former home, allegedly under the Animal Welfare Act, has already been covered. In this video, I will reveal a few documents concerning the case brought against me in 2008. I will leave you to draw your own conclusion as to whether or not the council vet was being honest in the statements he gave against me and subsequently to the High Court in 2011. In July 2010 at Cardiff Magistrate's Court, I presented an application before a district judge asking for summonses to be issued against Amanda Ewington-Gape, a licensing officer employed at the Vale of Glamorgan Council, and their vet, Mark Evans. My application against the two defendants was brought under Section 4(1) of the Animal Welfare Act 2006 for offences causing unnecessary suffering to an animal. The district judge was good, but he had no option but to rule that I was out of time to bring my case. He did not state that my application was without merit, an interesting legal point, as usually if a case is considered to be without merit, a judge will often use that as a reason for refusing the application. This would then be recorded in the court files. The basis of my claim was simple. At 8:05 on the morning of the 4th of July 2008, the licensing officer led and executed a warrant to enter my home, accompanied throughout by Mark Evans. At 8:15 that morning, Mark Evans was examining a bearded dragon in my home, which I explained had sustained a recent minor injury during transportation. I was already treating the injury with a veterinary manufactured product. After his inspection, licensing officer Amanda Ewington-Gape asked Mark Evans to write a report. His report dated the 12th of August 2008. On page 6, paragraph 2, he states, "This wound must have been causing the animal chronic pain and discomfort." Nowhere in his report does he state that he administered immediate pain relief. There is a legal, moral, and professional expectation to administer pain relief without delay if what he stated against me was true. The question is, why did he not take this immediate course of action? It is incomprehensible beyond words that the licensing officer, who had obtained a warrant to enter my home alleging evidence of unnecessary suffering to an animal, would be found, who must have then been advised by the vet standing right next to her of his apparent opinion. She then took no action herself to ensure the suffering was immediately alleviated. There are 5 freedoms to protect animals which were enacted under the Animal Welfare Act 2006. They include the right to be free of pain, injury, and discomfort. At just gone 1 o'clock that lunchtime on the 4th of July 2008, Mark Evans decided to remove the animal along with others from my home, taking them to his Cardiff surgery just 15 miles away. He had complete care and control of the injured animal from 8:15 that morning right up until 5 p.m. that evening. At 5 p.m, 1700 hours, he completed the animal certificate under Section 18 of the Animal Welfare Act 2006. He stated clearly and certified at 1700 hours that the said animal is suffering. By omission, when you read his report dated the 12th of August 2008, it is clear he gave no immediate pain relief or treatment whatsoever to this injured animal, despite his opinion. Either the animal was suffering, as he stated, or it wasn't. It wasn't just pain. According to Mark Evans, it was chronic pain and discomfort. It has been confirmed to me that Mark Evans did make contemporaneous notes when inspecting my animals. I have made numerous requests to have disclosure of these notes. On the 10th of March 2016, Hill Dickinson, the solicitors representing Valley Vets Limited and their client Mark Evans, confirmed to me that repeated requests had been made by myself for disclosure of the notes. They also confirmed that these notes are no longer in existence. 9 months later, Hill Dickinson sent an email to South Wales Police dated the 15th of December 2016. They sent a copy of the notes to South Wales Police on the basis that they must never disclose them to myself under any circumstances. I can only assume that their refusal to disclose the notes was because what was written in the contemporaneous notes was different to what Mark Evans stated in his report, which he wrote 5 weeks later. I knew what Mark Evans had stated was completely untrue. Based upon these documents alone, my solicitor should surely have challenged the vet's statement as part of the defence he was employed to represent me. Had he done so, on this express point alone, I believe the case against me would have collapsed. The licensing officer, who I had lodged several formal complaints against in the 12 months leading up to her executing the warrant at my home, must have been very happy to have the vet state what he did. Such a statement was paramount for her to successfully case build against me. The licensing officer had removed such a volume of property from my home on the 4th of July that it caused an immediate cessation of my successful business. When case building against me, the licensing officer had to ensure they would get a conviction, as my solicitor had already warned the council that in due course I would seek compensation for the damage they did to my business. 1 week after removing the bearded dragon from my home, it was well enough to be discharged by Mark Evans and was given by the Vale Council to a local animal sanctuary. In possession of these documents and with a feeling that there was a real duty to tell the truth, in 2011 I attempted further court proceedings. I attempted to sue Mark Evans for damages in the High Court, Cardiff. I felt he had a professional duty to answer in court why he failed to administer pain relief to the animal without delay if it was in such pain as he had stated against me at the original case. In his statement to the High Court, dated 31st of August 2011, on page 3 at paragraph 9, Mark Evans refers to the day he attended my home with licensing officer Gape, 4th of July 2008. He states, "At that stage, in my professional opinion, the wound was causing chronic pain and discomfort. It must surely follow if the evidence he gave to the High Court was true, why did he fail to administer any treatment to this animal for a full 9 hours after apparently making his diagnosis? I have consulted with a very well-qualified exotics veterinary surgeon who used to hold the position of veterinary surgeon at a well-known zoo. I asked him to consider the papers in this matter, especially concerning this aspect. In his statement of witness, he states, I am at a loss to comprehend why the Vale of Glamorgan Council, having sought and obtained a warrant to gain entry to a private property, on the grounds that alleged unnecessary suffering of animals would be found at the property, then apparently discovering such evidence and seizing said animals, failed to ensure that the necessary pain relief and treatment were administered. Instead, they were not given any attention for a further 9 hours. The High Court ruled that my claim should be struck out. They determined that Mark Evans did not owe me any duty of care because he was working for the Vale of Glamorgan Council. They were paying his invoices. Therefore, his duty of care was to his employer, the Vale of Glamorgan Council, and not me. It has been estimated a figure in the region of £4.2 million to be a conservative calculation of the actual and consequential financial loss I have suffered since this matter began in 2008. For the record, no evidence whatsoever which the licensing officer had alleged to the magistrate she would find at my home was ever found. The warrant gave licensing officer Amanda Ewington-Gape certain powers under the Animal Welfare Act, but it did not give her or the Vale of Glamorgan Council authority to investigate my VAT affairs. When I asked for my VAT books and records back, as you can see, the council refused, stating Some of the items you requested for return are still relevant to the investigation and will not be returned to you at this time. For the past 11 years, I have relentlessly attempted to seek a proper court hearing in this matter, a hearing which continues to be denied to me. There is now little expectation on my part that I will ever have any sense of justice in this unique animal case. I am not the only person who feels that justice continues to elude them. There are many other cases of injustice, serious cases, including those of the relatives of the Hillsborough victims and the family of Harry Dunn are just two prime examples. They have never received justice and they never will, but like myself, they keep trying day after day. Whilst the whole case was at the time of the original proceedings reported very one-sidedly, with a very poor defence from my solicitor, who wrongly convinced me to change the not guilty pleas I had first entered in court to guilty, I wanted to take this opportunity to focus on what is considered to be a major fault with the original prosecution case, a case which no court wishes to see reopened. If they did allow that to happen, it could seriously affect the careers of a number of people.